Good morning, Oklahoma. This is Katrina Lucas with Wirth Law Office. I'm here to ask a common question that occurs in all of my client meetings when I talk about estate planning, and that is, what is the difference between an irrevocable and a revocable trust? An irrevocable trust means that once funded, once the items are in the trust, they cannot be removed back to your name at your own discretion. An irrevocable trust is managed by somebody else. An irrevocable trust requires you to have a trusted advisor, a trusted family member, a trusted friend to be able to control those assets on your behalf. They owe you a fiduciary duty to do things right, but you cannot call them to do anything for you at any point in time unless they deem it in alignment with the trust language. They have to approve, they have to sign. You no longer own those assets. The benefit of an irrevocable trust is that an irrevocable trust is not assets to be looked at by the government to see what level of estate you have. So, in case you are looking at Medicare or Medicaid situations, whether you're looking at government benefits, whether you're looking at long term in home care or out or facility care, those type of situations require an analysis of those assets. And if you have done an irrevocable trust a period of time prior to those moments, those assets do not count as yours, although they still service your needs and provide for you during your life. The reason that you would not want an irrevocable trust is that if you don't set it up correctly with the tax code, it can be taxed much higher than a person would have had their normal assets. It has to be, you have to use certain tax codes for that trust so that you don't get taxed at a higher level. An irrevocable trust requires its own tax ID number. An irrevocable trust requires every item to have a signatory that is not you on it. An irrevocable trust cannot have its language changed unless done within certain provisions using a trust advisor. An irrevocable trust is still a better option than nothing when it comes to estate planning if you are looking at long-term care where you're going to need to use an in facility and Medicaid or Medicare. Now, a revocable trust is typically what most attorneys are going to provide for you. A revocable trust or a living trust, those two names are used side by side. They are the exact same meaning that while you're alive, this trust exists underneath your full control, and you can fully dictate all terms and everything within it. You can have an attorney write it and then change that language the next month. You can change who is going to benefit after you are incapacitated or after you have passed away. A revocable trust is completely under your control. However, a revocable trust does not protect your assets completely from creditors or from liabilities. A revocable trust may be able to be seized in litigation or other situations if it's deemed that you did something egregious and very wrong. It has to be extreme. It is not simple negligence. It's not a car accident without extra facts that goes into it. This isn't a typical creditor. It's not a foreclosure creditor. This is a person that says that you did things fraudulently and with intently, almost criminal intent. The federal government might go into your revocable trust for IRS reasons, if for taxation avoidance. Those are things that it might go into your trust and be able to seize those assets, but they are few and far between. Both a revocable and an irrevocable trust avoid probate. Most people don't know what probate is, and I'll be talking about that in another video. But if you do know what probate is, and you do want to avoid it, this is something you need to look at. If you have any questions or need to do some estate planning discussions, please feel free to reach out at me at Wirth Law Office. I'm excited and always happy to do this type of work for my clients. I'd rather be in the planning stage than to be hired in a probate.